Hi friends from around the world. Do I choose my cases only if there is a famous company involved like Ferrari or like Prada or others I have done? No, that is not the case. What happens is that these famous names, they have deep pockets and they have high stakes in their cases, and they are prepared to go further, higher in the ladder, and they go to the higher courts. And therefore they are more represented in these cases, in these landmark cases, than others. So that is not I choose the cases from their educational and their doctrine level and their closeness to practical the issues which you may have as a lawyer, practical lawyer from outside, from around the world, or even in Europe. Now, this is a case from Coty, which is Coty, which is a German company, a licensee from Davidoff, and they had these hot water bottles, perfume bottles from Davidoff under their operations. And they saw Davidoff, which was as infringing goods offered on the Amazon marketplace in Germany. Thus, so the marketplace in Germany is where Amazon has constructed a kind of marketplace peer-to-peer, where third parties can offer their goods on the Amazon marketplace, Amazon platform, so to say. But the contract would be contracted, would be closed, would be done between the parties without dealing with Amazon. So Amazon was not in the contractual issues here inside. Amazon was so to say only a storehouse, so to say, a warehouse where it is dispatched once the contract has been closed between the parties. Now, the German company Coty, they sued Amazon in Germany in the EU trademark court. So I talked a bit about the EU trademark courts, but only in a preliminary way. What we have Article 123 European Trademark Regulation and Article 80 of the Community Design Regulation. Both of them establish the necessity, the obligation for member states to determine national courts which deal with community designs and European trademark. So they get knowledgeable in that, specialized, so to say, in these issues, and they can render some judgments which are based on knowledge and not disparate in any way. So that I think was a good thing. And you have now the possibility and the necessity to go to these trademark courts. There are only 2 or 3 within some member states, so they are very limited in the number. Okay, coming back to the case, the case went up to the federal court, and the federal court had some problems in deciding here, and it was about Article 9 of the EU trademark regulation. Article 9 is about what can be done, what are the rights which are conferred to the trademark holders, what acts can they prohibit, so to say. And there is Article 9.2, which says about the use in the course of trade, and Article 9.3 is a bit more explicit as to exactly what can be prohibited, so to say. And in Article 9.3 we talk about the stocking of goods. Now, the considerations of the German Federal Court was around that. So what does it mean, the stocking, and is that a possibility that the case of a warehouse keeper Amazon, but a platform which is used by them, etc., if this is use in trade in the sense of Article 9.2 and stocking of 9.3, so that then, if so, the responsibility of Amazon would be there. Now, this is an important question because Amazon has deep pockets, right? So if Amazon is being condemned here, so would be the losing party, then it would be good for the trademark owner because they would get reimbursed and they get the damages, etc. Whereas if it is, the small trader, the outcome would be probably good, but if the execution of the judgment is also good, that is still another issue. Now, the European Court of Justice, through the referral of the German Federal Court, they went into the issue, but they were reluctant. So they say use in the trade need to be some actively supported actions from the platform, rather than being limited to the, so to say, warehouse keeping, to the stocking and dispatching. So there's no control of the part of Amazon with regards to the destination of the products. They just act as somebody who is ordered to do this or to do that. Meaning that Amazon, according to the European Court of Justice, was not responsible for what has been the stocking as use in the course of trade. So this is good for Amazon, right? But it is also probably the recognition of a contractual situation, a law construct, so to say, in order to exonerate the Amazon, the platform, from its responsibility. It is true that it was not being proven that Amazon knew that that was a fake product. Right? That would change the situation a bit. But it was also not established by the Court of Justice that Amazon has a kind of obligation to look whether there are fake goods on their platform. So there's an interesting issue here. The Attorney General, I referred on various occasions to them. The Attorney General is somebody who gives an opinion before the ruling and guidance to the court in order to render the judgment. And here, the Attorney General, in its opinion, so to say, which can be looked up by you, the Attorney General, it said, well, there is a possibility of Amazon to do something more. So they have a possibility to look out for infringing goods on one hand, and the possibility that they dispatch and they have the goods under their control. That is something more than a mere warehouse keeping, so to say. So the importance of the present judgment is more what is not saying, rather than what it is saying. So the absence of any comment on what has been said by the Attorney General is it be interpreted that they don't want to go into this, or that they think that is not important, or they think they do not have the authority to do so because of the question or whatever? We don't know exactly. We will know better once we get perhaps another case being referred to the Court of Justice, where the situation is a bit more clearer. But it is an important case. Remember the case the other of cognac and what is it? Cognac and cigarettes. That was the Finnish guy in the video series here. And there was a possibility also over the general court. Well, it decided in the same line, but it was an individual here. And here we have somebody, Amazon, which is one of the biggest company in the world. So it could have been differently decided here. It is an important case for the practice, I think. You will be able, or you will have the possibility probably once in your practice to go against a infringer on the Amazon website or on any other website platform, marketplace platform, what is it, eBay or whatever. And you may have this doctrine to be applied or argumentation to be presented, use in the course of trade, and you need to go deeper into it. Now that case here is, so to say, the prolongation of a previous case, which is L'Oréal eBay, some time ago, from 2011, here on the screen, which also went into the exoneration of these platforms. At a certain moment, I think this has to be reversed, and we are, I'm waiting for a judgment which goes probably at a certain moment the other way. Thanks for sharing time with me on this one.